Assembly of Kirinyaga has filed several documentation that constitute new evidence, which was not in the evidence that the governor received from the Speaker of the Senate. The committee responds to each of the following issues here under. On the issue of availing clear copies of the County Assembly, the committee hereby directs that the governor provides clear copies of the said documents by the end of today, that is on 23rd June 2020, serve the Assembly's lawyers via email and copied to the clerk of the Senate. Second, on the governor's request that Mr. Joseph Karilas Otieno, who has been summoned by the committee, be allowed to appear tomorrow as a witness and be cross-examined by the committee is hereby convinced that the request is reasonable and will not prejudice the Assembly's case. The committee therefore directs that Mr. John Otieno shall appear tomorrow, 24th June 2020, and the County Assembly shall be at liberty to cross-examine the witness on the issues raised in the summons during cross-examination. Third, on the preliminary objection to the form of the document filed by the County Assembly, the committee notes that it would have been desirable for the County Assembly to present well-bound documents, properly paginated, to assist the committee and all parties in understanding and deliberating on the matter herein. And therefore, our Secretariat will also furnish the council representing Governor Waiguru with a well-paginated document, if you so require, to help you execute your matter. Fourth, on the issue of introduction of new documents and evidence, owing to limited time available for this committee to present its finding to the Senate, the committee notes and encourages the parties to canvass this issue during hearing, and the committee shall proceed with the documents as filed and make appropriate determination on the veracity, admissibility, and propriety of the evidence in making its final determination in accordance with Rule 19 of the 5th Schedule of the Senate Standing Orders. That is our ruling, and I will now guide the meeting as follows. We shall allow the opening statements because of time. We shall listen to the opening statements from both parties, 30 minutes each, and then we shall break for lunch. When we come back, we shall now have time to start the County Assembly presentation. So we shall start by opening statements on behalf of the County Assembly of Kirinyaga. Do you have anything?
Chairman, just to thank you for your very clear directions, and to put it on record that we would very much appreciate, before we start with the afternoon session, a clear and paginated copy of these documents so that we can follow the proceedings. Thank you very much.
Okay, we shall ensure that our Secretariat furnishes you with the same. Yes?
Much obliged, Chairman. With your kind permission, I would begin to probably give my opening statement, and we highly appreciate the committee's findings. Mr. Chairman and the honorable members of the committee, today the Assembly is being called upon to look into the conduct of the Governor of Kirinyaga County insofar as the question of good governance the question of proper administration, the question of accountability, the question of transparency, and the question of abiding to the rule of law is an issue. Mr. Chairman, this committee has congregated here pursuant to a motion that was passed, or a resolution that was passed by my clients, the County Assembly of Kirinyaga County. Suffice to note, Mr. Chairman, that the County Assembly is constituted of 33 members, and out of that 3 members, 23 returned a positive verdict that it saw or deemed it fit to have the governor answer to these charges. Suffice further to note that out of the persons who attended the proceedings on that day, it's only 4 members of the County Assembly who abstained. Abstinence does not mean a vote of yes or a no. That means, honorable members, that the County Assembly, in execution of its mandate under Article 1, where the sovereignty belongs to the people, congregated, and out of the 30 wards present in Kirinyaga County, 23 wards felt that they have no confidence in the manner the county is being run by the governor. Honorable members, we shall be able to present witness and evidence to prove and to adduce evidence towards the charges facing the governor. However, before we get to that position, honorable members, I wish to invite the committee to move with me that we are looking at a very complex case of corruption, a complex case of misappropriation of public resources, a complex case of mismanagement of public resources. We all understand that corruption and issues of public mismanagement of resources is a complex web. The committee might be then asking itself, how is the Governor Waiguru involved in the processes of the tender? Does the governor sit in the tender committees? That might be the question that the Senate might sit to resolve at the fullness of time. But as I said, that the question of corruption and mismanagement of public resource is a complex web. We shall be calling witnesses to show and to demonstrate to this country who are the owners of the monies that the County Assembly is rising up to defend, that Governor Waiguru's hearts were in the cookie jar. We have witnesses to testify that besides Governor Waiguru not sitting in any of the procurement committee, her hands were present. What am I saying, honorable members? I am saying that we shall be able to demonstrate nexus. The nexus between the conduct of the governor and the persons sitting in those tender committees. Remember, honorable members, that when this House and the National Assembly sat to legislate on the Leadership and Integrity Act, they legislated a very interesting Section 35 of the Act. And Section 35 of the Act was actually looking into or foreseeing a situation that faces us today. Which situation is that? A situation where the governor sits far away from the committees procuring the tenders or evaluating the tenders, but our hands are in the cookie jars. And what did the National Assembly do? The National Assembly legislated Section 35, which we shall be submitting on. What was that section providing for, honorable members? That even when a governor or a state officer or a public officer moves to perpetuate the abrogation of Chapter 6, when the state officer or the governor moves to perpetuate the abrogation of the PMF Act, when the governor moves to perpetuate a transgression on the Public Procurement and Disposal Act, she could be acting through the influence of others. We shall be able to lead evidence to demonstrate to the committee members that Governor Waiguru is not even cognizant of the provision of Section 30 of the County Governments Act, which provides that the governor has the capacity and the responsibility of offering leadership in the executive committee and in the administration of the entire county. We'll be able to highlight what actually administration of the county means. Administration of the county means that there must be a nexus, that the governor is not a governor executing executive functions only, that the governor must also be in charge of the administration of the county. And that, honorable members, we'll work with you in the provisions of Article 179, which designates the governor as the chief executive officer. The chief executive officer of Kirinyaga County. It then means that the chief executive of Kirinyaga County must be cognizant of how the affairs of the county government are being run. In the absence of demonstrating leadership, honorable members, is that governor supposed or conveniently capable of executing the functions bestowed on her? We'll be answering that question in affirmative, that yes, the County Assembly of Kirinyaga was justified. The County Assembly of Kirinyaga was convinced that Governor Waiguru does not deserve to continue serving as the governor of Kirinyaga County. There may be arguments that this is a witch hunt. There may be argument that might be brought forth to convince this assembly to look at the question of protection of devolution as provided for under Article 96, the roles of the Senate. But is a question of protecting, and this is a question we shall ponder, all of us, at the fullness of time. Is a question of protecting devolution include protecting inefficiency? Is a question of protecting the devolution include the protection of an individual who has exhibited clear manifestation of her inability to govern? Honorable members, we'll be working with you towards that path. Remember, honorable members, that the governor of Kirinyaga County is mandated under Article 3 of the Constitution to defend the Constitution and uphold the same. What then becomes of that governor who abrogates and who causes or who supervises or who oversees the abrogation of Article 201 of the Constitution? What is the fate of this governor who abrogates Article 227 of the Constitution? What is the fate of the governor who abrogates Article 185 of the Constitution that gives the County Assembly the mandate to carry on the functions of oversight? Honorable members, Article 10 of the Constitution is clear as to what is required of Honorable Governor Waiguru. Honorable Governor Waiguru is bound by the provisions of Article 10, Clause 1 and Clause 2. And the provisions have no ability of a waiver. No state officer, not even the Senate, nobody in the Republic of Kenya that can waive or immunize himself from the application of Article 10. The principles and the values of governance enshrined thereto provides that the same bites all state organ and state officers whenever any of them is implementing the law or interpreting the law or any policy. We shall be asking this question. Was Governor Waiguru faithful? Was she faithful to the provisions of that article? Did she ensure that there is accountability in the way the county is managed? Did she ensure that there is transparency in the manner in which the tenders were issued? Did she ensure that there was no nepotism, there was no favorism, there was no chronism, there was no aspect of favoring individuals, particular companies, with the award of the tenders. What of those individuals, honorable members, who sat in those committees, who have a clear connection and nexus with the governor? We shall be leading evidence to that effect, honorable members. Most importantly, evidence leading to the question of Pauline Wairimo Kamau. Suffice to note that evidence shall be led to prove that prior to her becoming the director of administration, besides her unqualification, the same was previously serving as the governor's personal assistant. We lead evidence, and we honor and we are highly humbled by the summons that were issued by the committee to the chair of the Public Service Board, who will adduce evidence that yes, such officers did not warrant their appointment or their recruitment, had it not been for the influence of Governor Waiguru, had it not been for the influence of Her Excellency, had it not been for the intimidation of Her Excellency, we then be asking ourselves, what was the relevance and what was the urgency and what was the expediency that was supposed to be served by this officer? We'll be leading evidence that she had not even qualified to hold a position of a director of administration. To that effect, honorable members, we'll be seeking leave from the Transitional Authority guiding manual on the persons holding the office of the staffs in the office of the governor. We shall further lead evidence that one Wayne Gishira, who is currently designated as the ICT advisor in the office of the governor, had his hands in the cookie jar, and that those hands were in one way or the other the hands of Governor Anne Waiguru. We shall lead evidence to this committee that this Wayne is even holding an office that is not even created and prescribed by any manual. We lead evidence that the Transitional Authority, through an advisory, sometimes back in 2013, they actually said such kind of staffs cannot sit in administrative or executive functions. Then we shall be asking ourselves, whose interest was this individual serving? Honorable members, to that effect, I'll be calling four witnesses, including the one that was summoned and the ones that were summoned by the committee, to prove that Governor Waiguru does not deserve to serve as the governor of Kirinyaga County. And is this being done by bad faith members? No, it's not being done in bad faith. It's only being done so that we can protect the public finance and the public resources. When a single coin is lost in Kirinyaga County, that single coin belongs to the people of the Republic of Kenya. And that is why this committee is sitting to represent the Republic of Kenya in this impeachment process. But the biggest question would be, shall we be able to demonstrate that Governor Waiguru was in breach of her fiduciary duty to the people of Kirinyaga County? Yes, we shall. We'll be calling those particular witnesses. Honorable members, at the fullness of time, this House will believe in our story, that we are acting in good faith, that we are acting to protect the public funds, public finance, and not just that, honorable members. The 2010 Constitution, the one we adopted, if you look at the preamble there too, the adoption of the 2010 Constitution was adopted for this generation and our future generation. It then has a question of intergenerational equity and intragenerational equity. The biggest question is, in terms of leadership, in terms of integrity, what are we teaching our children? What ethics are our leaders teaching to our children? We'll be able to prove that Governor Waiguru does not portray a good example in this generation and even for the future generation. Remember, the work that we shall do today shall go on record. This is a house of record, and our future generation shall have reference to what we did today. History will judge us whether we did the correct thing to protect the Republic from flagrant fraud and flagrant theft of national resources. Honorable members, this is not just a case for Kirinyaga County. It is a case for the Republic of Kenya. The person at Homa Bay, the person at Kilifi, the person at Lamu, the person at Bungoma, the person, the Mama Mboga at Bungoma, the Mama Mboga at Kirinyaga County, Murang'a County, and all the 47 counties contributed to the penny that the Kirinyaga people are seeking to protect. It is therefore incumbent upon us, and most importantly this House, to make sure that devolution is protected, not by protecting those that have questionable conduct, not by protecting individuals whose public management is in question, not by protecting individuals who go rogue on the question of the application of the law, but protecting devolution in the right manner, in the right form, and in the right context. Honorable members, will be able to demonstrate all those issues that the County Assembly has raised. Look at the conduct of Governor Waiguru when she is called upon just to have an honor among the persons whom she was elected in office with, the County Assembly. She has an attitude that the County Assembly are not people worth of listening, are not people worth of my address, are not even the letters written to them, are not worth of any response. But does the County Assembly exist in utopia? No. The County Assembly exists in law. Article 176 has constituted the County Assembly and the County Executive as one organ. There is no separation. There is no pure separation there too. And that is why the Constitution has provided that there is established a county government which shall consist of the County Executive and the County Assembly. That creation of that organ without a clear distinct as it exists in the national government presupposes that there is no one who is above the other. But what is the conduct of Governor Waiguru? Governor Waiguru has chosen to undermine the authority of the Assembly. Governor Waiguru, for one reason or the other, became drunk of power. Governor Waiguru, for one reason or the other, failed to submit to the jurisdiction of the County Assembly. The biggest question then that this committee will ponder is one, in the event where the Governor Waiguru fails to submit to the authority of the Assembly, how will the Assembly execute its oversight mandate? The other question is, was the deliberate attempt or deliberate actions of undermining the County Assembly by design or by default? We'll be answering in affirmative that the failure or rather the question of undermining the County Assembly was not by default, it was by design, to make sure that she removes herself from the ambit of oversight by the County Assembly. In such kind of circumstances, how can or how will the government of Kirinyaga County continue to exist with a governor who feels that he or she is above the County Assembly? The question of undermining the County Assembly undermines the supremacy of the people of Kirinyaga County, undermines the sovereignty of the people of Kirinyaga County, because they are not, Governor Waiguru is not in office by her own operation. She is in office by the operation of the law. that people in 2017 cast a vote. She cannot then be seen to undermine that vote. It is now the time to teach the current generation and the future generation that such an action of serious transgression to the law cannot go unpunished. These records of today will be records of tomorrow. We must make sure that we get it right from the beginning. Honorable members, as I sum up, Governor Waiguru does not sign any document. So from the bundles of the documents brought in today as our evidence, and even the evidence from the county executive, you will not see her hand in it. That is how clever, and that is how these aspects of abuse of office, this is how aspects of plundering public resources manifest themselves in our case. That the signatures were put by individuals, not voluntarily, but through coercion, intimidation, and through the forceful might of the governor of Kirinyaga County. Honorable members, I'll cite to you 3 companies, one called Velocity, and I wish to spell Velocity is VOLECITY. I will also cite in our submissions a company called Velocity, which is VOLECTY. You may not be clever to have a distinction of those 2 companies. I'll show you how it manifested itself. That a company that was incorporated in 2017 can bid or can participate in a bid, in an open bid, 2018. That a company that was incorporated in 2017 can allege to be having audited accounts for 3 years. That a company that was incorporated in 2017 can allege to be having an experience of 5 years. A company is awarded tenders worth millions of money. The company does not have any experience. It has not met the threshold of the Public Procurement and Disposal Act, but the company is let go under the auspices or under the watch of Governor Waiguru's employees, under the watch of Wayne Gishira, the advisor to the governor. I will demonstrate to you, and it has been captured in the response by the governor, that how one company associated to the chief finance officer, one Mogondadi, was always favored with tenders. These tenders, some of them were classified tenders. I'll then manifest to you during our evidence that it was not in default that Davi Mogo became the chief officer. We'll be adducing evidence that it was a favor that was being returned. Whose favor was it being returned to? It was being returned to one Mr. Edwin Geshobi Ndadi, the brother to the chief officer. I'll show you how transgression manifested itself. That even in the midst of the clear provision that one must declare a conflict of interest, that was never done. Honorable members, I'll demonstrate to you, or we shall demonstrate to you, how a motor vehicle worth 14 million was purchased to ferry Governor Waiguru. We'll be asking ourselves whether it was necessary, whether there was expediency to purchase the same, or the expediency was motivated by ulterior motives. Yes, we shall. We shall demonstrate this to the members. I will demonstrate to you through evidence that the processes of procuring this motor vehicle actually transgressed the provisions of the the provisions of Public Finance and Management Act. I will show you how a governor sits in her office and decides to issue a guarantee or to apply for a guarantee without the sanctions of the national government, without the sanctions or without the approval of the county government. She became a law unto herself. She legislated and executed the legislation. She did what she felt, or what she felt would serve her interest, not the interest of people of Kirinyaga. We shall further demonstrate to you how Governor Waiguru, in alleged foreign travels, was not or did not even step her foot to those countries that are alleged. And where she never did, she was not even as quick to refer the money advance to her. That is Governor Waiguru for you. That is Governor Waiguru, who is leading the county of Kirinyaga County. Governor Waiguru, is she fit to serve? That is a question that shall be brought through our evidence. I'll show to you, and witnesses will testify, how during the previous conferences of county government conferences, the one that was held in Kirinyaga County, a demonstration was staged to mean that Kirinyaga County has opened a coffee shop in the US. I'll show you through witnesses that the office or the coffee shop does not exist, despite spending money towards that particular process. Who suffers here? Is it only the people of Kirinyaga County? No. We are all held hostage by this rogue governor. The country has been held hostage by the action of this governor. We do not want to cite her previous engagements, but we are only looking, and I know the committee will be taking judicial notice of the same, that they actually raised issues. As we proceed, honorable members, at the fullness of time, we'll be able to demonstrate this. We highly thank the committee.
Thank you, Mr. Ndegwa. I would like to bring to the attention of both parties that in the parliamentary time management practice, I will be using these three lights to signal the time remaining to make your respective submissions. These yellow lights will signify that you're remaining with 10 minutes. And then this green light will signify that you are remaining with 5 minutes. And lastly, the red light will signify that your time has lapsed and you will no longer be heard by this honorable committee. Thank you. You may proceed. The council representing Governor Anne Waiguru. You have 30 minutes.
Chairman, good afternoon. Unlike the governor's accusers, the governor is prepared to meet her accusers herself. Despite some of the strong and inappropriate language that has been used by my good and learned friend for the county assembly, we hope that he will be able to prove what he says. We will share the 30 minutes between ourselves as councillors and the governor, and Her Excellency will go first. Thank you very much, Chairman.
That's okay. So, Governor Anne Waiguru, you may come.
Thank you very much, Honorable Chair, Honorable Senators. Today marks an important milestone to the development of our system of devolved government. The Senate, through the committee, is called upon to play one of its most critical constitutional mandates, that of determining whether an elected governor should vacate office pursuant to an impeachment by a county assembly. Let me state at the outset that I believe in the right of the members of county assemblies to carry out oversight over the executive. I believe it is their legitimate right and constitutional duty to impeach a governor if and when the circumstances exist to justify such an impeachment. Such oversight processes are essential in ensuring transparency, accountability by those of us who have been privileged to hold critical leadership roles. However, it must be recognized that the removal of an elected official is a solemn responsibility, as it overturns the democratic choice of the voters. In the case of Kirinyaga County, it seeks to substitute the will of over 159,000 citizens who voted for me on 8 August 2017. Consequently, such a process must only be carried out in extreme circumstance. Honorable Senators, you are no doubt allowed to the reality that an impeachment motion is a vastly time-consuming exercise which takes away valuable time of all parties involved, including the MCAs, the subject governors, this House, from other critical businesses. That is not all. It also infects the political environment of a county so severely that very little proceeds in the county when this process is going on. Currently in Kirinyaga, budgets are not approved. My officers are summoned daily and issued threats that they will be removed from office or otherwise sanctioned. As a matter of fact, in the last 1 month, 2 CECs and 1 CEO and the county secretary have been given a vote of no confidence by the county assembly. Critical state officers, including CECs and members of the County Public Service Board, have not been approved by the assembly, making it difficult to employ staff even for critical health services. Services to the people of Kirinyaga are affected and will continue to be affected, even when this process is over. Whatever its result, the negative impact of the process will linger. It is also an expensive process for all concerned, with lawyers and other professionals, tons of documents, witnesses, and other attendant costs. It is therefore not surprising that the Constitution and the County Government Act reserves the impeachment solely to circumstances in which gross and serious violation of the Constitution and the law and serious abuses of office are proved to have been committed by the governor. The courts have severally and consistently given decisions affirming the need for those seeking impeachment to obtain a high threshold for misconduct and violations of law before they can successfully remove an elected officer from their position. Impeachment and removal from office was never intended and should never be based on falsities, innuendos, rumors, hearsay, conjecture, and certainly not malice. Honorable Senators, secondly, an impeachment process is required by the law to be procedurally without reproach. It must respect the rules of natural justice, including the right to a fair hearing, and involve the people through public participation processes. That, as my lawyers will show, never occurred in this process. No formal public participation took place. The decision to proceed with impeachment, despite a subsisting court order, was made on Monday. I was purportedly sent an invitation to attend the proceeding on the same Monday to appear the next day. Truth be told, the notice to appear was brought to my office at 10 a.m. on Tuesday, when the motion was being debated. I was not even in the county on the day. By 3 p.m. on the same day, the impeachment proceedings had been completed. It is to avoid this sort of possible malpractice by county assemblies and to protect the integrity of the removal process that the drafters of the Constitution and the County Government Act wisely placed the Senate at the center of the impeachment process of governors. In this process, the Senate is a preeminent organ that ensures that the impeachment process is fact-based, has the requisite threshold, and is procedurally fair. The Senate is also to ensure that an impeachment process is not used to achieve collateral political purposes or push personal agendas. And it is not calculated to scandalize, embarrass, malign, or defame an individual. Unfortunately, what is before you is in every respect false, unfounded, and salacious allegations which have no place in an impeachment motion. Honorable Senators, my lawyers will be taking you through the allegations that formed the basis of my impeachment. Without rehearsing that presentation, I must say that the grounds that form the basis of my impeachment and which this committee is now asked to superintend are an affront to the very serious process that the Constitution and the law have prescribed for the removal of a governor from office. The grounds contain allegations that are obvious falsities, unfounded, and malicious. They relate to minor administrative issues that would easily have been clarified by a routine inquiry. How can anyone justify summoning an entire county assembly and now the Senate, where the allegation asserting gross violation of the Constitution is failing to deliver a state of the county speech at the county assembly, a requirement that does not even exist in the Constitution, not to mention that I actually did deliver 2 states of addresses in both the years that I have been in office, with 1 scheduled towards September this year. That will be proven. How does the Senate of the Republic of Kenya be called to sit in inquiries into allowances to board members whose approval was made way back in 2014 by the SRC for all boards in the country? How can this honorable House be called upon to sit in review of tenders which were never appealed by the participating bidders, where there was no allegation of malpractice or non-performance or overpricing, and no single allegation that the governor was conferred any personal benefit or that loss was occasioned in the county? I would like to mention on one specific tender, the 15 million tender. This team will be shocked to know there was no 50 million tender given to Velocity, and that will be proven. There was also no 30 million shilling payment to Velocity, another lie done again for intended purposes of ruining somebody's reputation. That again will be proven by my lawyers. You will be shocked to find the allegations even include the purchase of the governor's vehicle, whose budget was duly approved by the same assembly. The purchase was not from a dealer, but from the manufacturers of the vehicle, Toyota Kenya, that supplies government vehicles under a framework contract negotiated by the Ministry of Public Works. Why would the business of Kirinyaga County be stopped at the Senate, as the Senate is called upon to interrogate travel impress? To show the extent of these falsities and the malice, the Assembly knowingly added 3 non-existent entries to the impress lists amounting to 4.6 million. These monies were never paid to the governor. They have no evidence to show that that money was paid. They were false entries to make and malign the name of the governor. Why else would an assembly do that? In their enthusiasm to prosecute the governor, they even allege I did not travel on trips where the leader of majority, the chief accuser in this process, was present and is photographed with me in the US and in Italy during those 2 trips. There can be no higher abuse of the process of impeachment, and indeed no higher abuse of the power of the Assembly than the process before you today. Honorable Senators, the Senate exists to protect devolution. While this must include strengthening the oversight capacity of county assemblies, focus must shift to protecting governors and county executives from the excessive overstepping of the oversight power of the county assemblies. Most governors avoid impeachment and firing of their cabinets only by bending over backwards to cater to the personal demands and whims of MCAs. Budgets are only passed if allocations are aligned to the personal desires of certain individuals. MCAs go as far as to demand to approve payments to contractors before they are made, contrary to the County Government Act. Failure to keep the MCA's wheels sufficiently oiled can earn you an impeachment. Unfortunately, all these prejudices, service delivery, and development in counties for which the governor is then held responsible. That is our unspoken reality. Unless the Senate deals with this problem with the seriousness that it deserves, Not only will anyone worth their name avoid seeking county leadership, devolution will not meet the intentions for which it was established. Honorable Senators, I wish to make one final point on the need to retain the integrity of the county assemblies. In the last 7 years, the Senate has invested significant resources in ensuring that the profile of county assemblies is raised so that they can represent the image of effective government at the grassroots for Kenyans. This is extremely important because the county assembly is the closest representation of Wanjiko in the lowest level of governing. It has been the desire of the Senate and those who believe in strong devolved governments to erase the history of councillors in the old local governments who were engaged in fisticuffs and other such unfortunate methods of handling council business and resolving disputes. It was therefore an embarrassment for us to watch my county assembly members sleeping in the assembly for a night prior to the impeachment proceeding and roughing up fellow members just for raising a point of order. This sort of conduct brings county assemblies and indeed the entire devolution system to disrepute and must be discouraged. While we have differences of opinion with MCAs, Kirinyaga has never been the subject of any actions that would require people to sleep in the county assembly and convert sittings to violent confrontations. Finally, honorable senators, I ask that you look into these matters dispassionately with an eye solely on evidence. I do not ask that you take my position as truth. I only ask that you ignore media tidbits and sensationalizations of tales. Listen only to the evidence that will be presented in support of the accusations and review the documents we have presented in support of our rebuttal and establish the truth. You will agree that this was an unfortunate process that must never be repeated. I ask, however, that if you find the allegations are malicious, unfounded, and were calculated for the mischievous purpose of harassing the governor of Kirinyaga, that you will declare these processes to amount to abuse of office by the MCAs. You would then be within your rights to apply appropriate sanctions, which your establishing law and your standing orders allow you to do. I say this because the Kirinyaga MCAs have made several statements that this is just one of many impeachments they have lined up to ensure they destabilize the county totally. While you cannot stop legitimate impeachment motions to be prosecuted, you must give sufficient guidelines that ensure that impeachments are not misused. It must not be made a tool for pursuing vendetta, and the Senate must not be made an accomplice to such endeavors. Once again, I thank you for this opportunity to address you. I believe that truth will prevail, and as is stated in our national anthem, may justice be our shield and defender. I thank you, honorable senators.
Thank you. Just before the council comes in, on a light note, Honorable Waiguru, I have heard you speak strongly about the members of the county assembly. It's high time you note that the chairman of these committee is a former member of county assembly.
I'm aware.
Thank you. Lead counsel, you may proceed.
Chairman and members, Chairman and senators, thank you very much for the opportunity to address you again. And I just want to pick up very quickly from where Her Excellency the Governor has finished off. And I haven't seen any of the colorful lights, Chairman, in front of you come on, and I believe we will have 2 or 3 minutes so that I can just follow on quickly.
You have 13 more minutes.
Thank you very much. Just to follow on quickly from where the Governor has finished off. Chairman and members of this committee, you have heard extensively from my good and learned friend for the County Assembly. And as you embark on the task that my good and learned friend for the County Assembly this morning very correctly characterized as truth-seeking, and having listened to the submissions or the opening statement for the County Assembly, for the Governor, we wish to urge that you bear one very important responsibility that this committee has in mind. And Chairman, with your permission, I will perhaps just... Thank you. Chairman, with your permission, an English saying comes to mind that I want to, as part of the opening statement by the Governor, put before you and your committee, and urge that you bear it in mind as you carry out your important task. And that saying is as follows, Chairman. The proof of the pudding is in the eating. The proof of the pudding is in the eating. The County Assembly must prove the allegations. We have heard the pontification by Learned Counsel for the County Assembly. It must now be followed up with evidence. Nothing less than strict proof. Nothing less than strict proof of the smoke and mirrors story that has been told on behalf of the County Assembly. We urge, and we have no doubt, that Chairman and members will listen keenly.
Please, Chair.
Lead Counsel, you're advised to use your microphone and be more audible. You may move it close to yourself.
Should I remove my mic?
Yes, yes, you can.
Chairman, I hope I'm now a little more audible.
Yeah, that's better.
Thank you.
We also have an opportunity to now see your face.
I was not hiding, Chairman. I was just keeping safe.
Thank you.
Chairman, nothing less than strict proof of the smoke and mirror stories that have been very ably told on behalf of the Assembly. They must be strictly proved. We urge that you listen to the evidence carefully. We urge that you listen to the cross-examination carefully. And Chairman and members of your committee, we have no doubt that you will apply the Constitution and the law. Thank you very much.
Thank you. Well put, honorable members. Ladies and gentlemen, I think it is now time to break for lunch. We shall have a 30 minutes break. We expect both parties to be seated by exactly 2:15. 2:15. And the senators provided lunch for all our visitors and honorable members. You'll be served your lunch in your respective holding rooms, just to ensure that we keep time. The meeting stands adjourned. Thank you.